Yes.
Well, I don't think we should say any more now.
Thank you. Someone may be going to give us some further materials, but maybe you, Mr. Brown. Not yet.
Now. I'll answer some of the court's questions, but I'm not going to provide the court with a document setting out the provisions. We discussed this, and we thought.
No. As long as it's done quickly.
Yes, I understand.
There's no particular magic in spoiling your lunch.
I am going to answer all of the court's outstanding questions, though, other than that. So what I propose to do is to take the court through the witness statement in a bit more detail, because there are parts of it that the court has not concentrated on, and it would just be helpful for me to anchor some of the points I'm going to make thereafter in the witness statement. Then I'm going to address the court on the law, and then finally I'm going to make submissions on the grounds of appeal, either in the order in which we took them in the first argument, or in the order that the claimants have taken them. We're neutral. So turning then, please, to Alexia Johnston's witness supplementary bundle.
I haven't bothered to check. We've been looking at one of them.
Yes.
There's one for each case. Are they substantially identical?
Yes. So, if you've been looking at the one at tab 15, I'll use that. Otherwise,
I don't really mind, but I think it makes sense to look at the one we were looking at before, which was 15. Yeah. At least was it? The one we were actually to by Mr. Drabble was the one at tab 70.
That's fine. Let's use that.
Is that, if that's equally good for you, let's do it.
So what is the purpose of this? Well, obviously grounds 1 and 2 are pure questions of statutory interpretation, but they will be informed by factual matters that underpin the scheme, and some of that is as set out in witness statement. Ground 3 is primarily a form of factual challenge, albeit it is of course put as rationality. But in terms of the detail then of what the witness says, the court will have seen that she's a policy team leader in the Department of Work and Pensions. The development of universal credit in the COVID-19 context, in this case, is probably not of great significance, but the danger in terms of using the individual cases and the fact patterns of the individual cases is that they were both cases that were processed during the pandemic, and the court will have seen from this statement that there was a very considerable increase in caseload, and that was accompanied by very considerable pressure upon the Department of Work and Pensions infrastructure. They're impacted by the pandemic, staff absences as much as anybody else. So the particular details in terms of how long it took to process individual claims are unlikely to be representative in terms of the individual cases, but it may not matter significantly. Certainly our case, and as the witness explains, is that it is absolutely a fundamental objective of the universal credit system, and indeed welfare generally, that one pays promptly. That is the hallmark of a civilised benefit system, and therefore it is a primary objective. And as my Lord Justice Nugee has made a point in oral argument once or twice already today, it's absolutely critical that people are paid promptly, and we absolutely accept and acknowledge that. That is a key objective, but balanced against that is another key objective, which is to pay accurately, and that means only paying to people who are eligible, and indeed paying in the correct amount. And more significantly, in the present context, there is the policy objective of combating and reducing fraud. We'll see this in the witness statement, we've seen it in some of the legislative material. But fraud is, of course, corrosive to the public good in the same way that unreasonable delays in payment are corrosive to the public good. Because the fraudulent extraction of money from the welfare system not only depresses the amount of resources that are generally available, but can also be used in order to perpetrate organised crime, etc. So it's perhaps obvious, but it is of course incumbent on the Secretary of State to ensure that the system is designed and implemented in a way that delivers both of those two objectives, which to some extent may operate in tension with each other. So in terms of what the witness says, paragraph 5, the development of universal credit, number of judgments made by the executive as to how best to implement the system having regard to the legislative infrastructure. And the witness makes the point in the second part of paragraph 5 that I've just made. It seeks further several objectives, including removing defensive benefits, making work pay, tackling inefficiency, fraud and error, and the simplification of a highly complex system. These objectives are themselves complex, and when they interact with each other, prioritisation is required. Accordingly, a number of judgments have been made as to the most appropriate way of designing and introducing the new system. Then one has the rollout and what is described as the test and learn process. And this is perhaps of most relevance to the appellant's third ground, because we entirely accept that we are right on the questions of interpretation, and really the only issue here is, well, what are the systems that you're putting in place in order to ensure prompt payment, and do they withstand appropriate scrutiny? Because that would be the only route available to the executive to ensure that people are paid promptly, i.e. putting in place systems that are administratively efficient and workable. And what the evidence shows is that this particular issue, in terms of delays in the allocation of a national insurance number, and before that verifying the documents required to allocate the national insurance number, those are processes that are capable of being streamlined to some extent, and that is in fact happening, such that the problem that was before the tribunal and is now before this court is one that is reducing, and reducing quickly. Then paragraph 7 of the witness statement, we accept and embrace that the principal function of the department in relation to state benefits is to ensure they are paid promptly and accurately. And substantial investment has been made in UC for this purpose. And then paragraph 7 summarises those two objectives: ensure that state benefits are paid as quickly as possible, and ensure that public monies are not lost to fraud or other incorrect payments. These priorities therefore can be in tension, and there will be cases in which eligibility and identity verification means that payments cannot be authorised for a certain period of time. And the witness gives some evidence about the robustness of the process during universal credit. Then national insurance numbers. So section B, the court will appreciate and would have seen from the Upper Tribunal's judgment that national insurance numbers themselves are effectively a matter of executive policy, so there is no legislative framework for the allocation of national insurance numbers in terms of who is eligible. That is a pure question of executive policy, and the policy that is adopted is to allocate a national insurance number, NIno, where there is a business case for that. What does that mean? Effectively, that means one of two things. Either the person is eligible to receive benefits, or wishes to access the labour market and is entitled to do so. So, generally speaking, leaving aside juvenile NIno allocation, i.e. allocation to every single 15-year-old in the country.
It's only those who claim child benefits, isn't it? Or am I wrong about that?
In terms of juvenile allocation to 15 and 16-year-olds, I will check. My lord might.
I thought if you didn't claim child benefit, you didn't get a national insurance number as a child. But when you claim child benefit, you do. But I may be wrong about that.
Yes. Well, the reason I'm hesitating is that it used to be a universal benefit. And
child benefit is a universal benefit.
Well, no, there's eligibility requirements now.
Oh, right, okay.
Before, it was universal in the sense of no financial eligibility restriction.
But you still had to claim it, and some people didn't.
Yes, you still had to claim it. Well, can I check?
It probably doesn't matter.
Yes. The relevant business case that we're talking about here, though, are people who are in fact eligible for social security, or people who wish to access the labour market, and we're concerned with the former, not the latter. Now, just in terms of one of the points that the appellant makes, and this again is their ground three, well, why don't you just start the whole process as soon as somebody presents their application? And the short answer to that is because you haven't established the business case yet, because you've not established that they are in fact eligible for benefits. So you have not brought yourself within one of the two policy reasons why the executive will allocate a national insurance number to you. And as we will see later in the evidence, the claimants are wrong. They were wrong below, and they're wrong to repeat the argument today. So this process of allocating a national insurance number is effectively duplicative of something that goes before and isn't something which actually requires resources. That's not the evidence, and it's simply wrong. This is a resource-intensive process. There are 400 specialist officers whose function is to allocate national insurance numbers who are security cleared for that purpose. They are doing a fundamentally different function in the state architecture from those of other decision makers, whether it's universal credit decision makers or other individuals carrying out different exercises. And one of the famous points, and I'll try not to anticipate everything, but they say, well, effectively there's a large degree of redundancy here. Those 400 people are not doing anything meaningful, and you can rely on everything that takes place before. We say that's just factually wrong. So national insurance numbers, they have history. It goes back to post-war welfare reforms. They operate for a number of functions. Relevantly here, they operate effectively as a form of identity verification, and they also operate so as to allow for a form of matching, i.e. matching payments to individuals. This goes back to the whole concept of having a national insurance record on a paper-based system. You would use the number to match the contributions with the individual's social welfare record. Now, of course, it's far more sophisticated these days, but the general principle remains that they are used for that purpose, and therefore it's convenient when it comes to universal credit that the system does in fact use the national insurance number in order to ensure that the electronic payment is made to the bank account of the person who has that national insurance number. But as we describe it in the skeleton argument, that's not what the legislation says, that's just an advantage, and that itself doesn't generate any delay at all, because the delay that's complained of is the delay in actually allocating the national insurance number in the first place. So the witness then, from paragraph 12, sets out the fraud issue. So it is a unique reference number integral to the department's aim of mitigating fraud in the benefits system. NIno makes it easy to identify identity theft. And that is the information that's provided in general terms. So identity theft, and then 13.2, a NIno can be used to someone's claim benefits as soon as consistent with one another or engage in work that would affect their entitlements. So, in a sense, in a very broad fashion, the witness is describing two different types of fraud. There's the fraud of somebody who's effectively claiming, but the information providing may be false in certain respects. For example, they may be cohabiting and they present as not cohabiting, something of that nature. That would be fraudulent. And the NIno is designed to try and detect that. But then it is also serving the function of detecting the rather more pernicious fraud, which is more organised fraud, where fraudulent documents are being used, individuals are seeking to actually positively extract money, not just on the basis of certain aspects of the claim being misrepresented, but as part of a general conspiracy, as it were. And the scheme operates to some extent to mitigate both of those types of fraud, knowing, of course, that it will never be eliminated. So fraud is a paramount objective of the function of NINOs. Efficiency is another one. So the system, and Parliament knows that the system is designed to be efficient. So the investment in the technology is intended to deliver a more efficient administrative system because that is in the public good. It allows payments to be made promptly and accurately if one can use sophisticated technology for that purpose, and ultimately increases the amount of money available for welfare. And the witness says, in the majority of cases, so this is paragraph 16, there is sufficient time for NIno to be allocated before the end of the assessment period and the point at which a payment of the claimant is paid. However, given the priority of combating fraud in the system, that is not always possible. And I appreciate that one needs to look at the general position, effectively the ground 2 argument, and then the advanced payment position as well. In the sense that they are separate. But in terms of the witness's evidence, in terms of the ordinary run of cases, there is sufficient time, but the mere fact that somebody does not in fact receive their NIno even within the 1 calendar month plus 7 days period is not itself evidence of delay, or what is described as delay, because there will be cases when verification takes longer than that, and necessarily so. In paragraph 17,
We don't have any figures, though. The majority of cases mean more than 50%. We don't have any statistical analysis beyond that.
you have some from the claimants. So they have identified, so Mr. Bates, for example, has a witness statement when he says he's identified 60 cases where it took longer than a month and a week.
Yes, and you make the point in your sentence, and that's 60 out of however many million it is.
Yes, and not only that.
But we don't. The only people who would be in a position to produce any overall statistical analysis would be the department.
Yes.
And we don't have any.
Don't have any because nobody's actually saying that there's a.
Yeah, well, no, I just wanted to know.
No, we don't have any. And what is more, if I may, that is because nobody is suggesting that we need to have any, because that's not the challenge. It's not suggesting that the system is systematically producing unfairness. Then paragraph 17, the following are examples of the UC system requiring a NIno to function effectively, and some of this will certainly be familiar to the court, but it's basically about information feeds. One doesn't need to be a data expert to understand that there's an obvious role in having a unique reference number when one has numerous data feeds. Now 18 points there, but I appreciate that 18 itself is not intended to be an answer to any of the grounds of appeal, but the witness makes the point that if one starts to resile from a process that does require the NIno, then all sorts of difficulties will inevitably arise. Now, what is important then is C and D in particular, because the claimants focus significantly on C, I think as part of their ground 1, so ground 3 arguments. And this is the point which, if I may summarise, is this. They say, well, your UC officer has done the job, so that means it's likely that your NIno officer can just rely on their work. That's it in a nutshell. And we'll have to confront this likely question when one's looked at what actually happens in practice. But what in fact happens then is that there are decisions, effectively, determinations. I don't want to use an unnecessary technical word, but the Secretary of State will decide all of the Welfare Reform Act aspects of the claim through the universal credit decision maker. So that individual will decide whether you're over the age of 18, habitually resident in the United Kingdom, etc. And therefore there is a decision made on all of those aspects. And that will result in the conclusion that you are...
Sorry, if we're passing on from para 19, Does this process includes verifying their identity to UC standards?
Yes.
Well, that isn't explained. Is that explained somewhere else?
No.
What does it mean?
It means that. Sorry. What does it mean by what does it mean? So what are those standards? Is that the question?
I suppose so, but that's the same question as how do you verify someone's identity to those standards? I mean, does it mean that you go and see them, or they come and see you, or you speak to them on the phone? I mean, what's the process?
Yes. In terms of what those actual standards are,
Yes.
that's the question of detail, which I'm very happy to provide. Do you inevitably see the person? No, you do not.
Hang on 1 second, so wait a moment.
But there is a difference, and I'll show you that there's a difference between that process of identity verification and...
Sorry, just before you said you'd happily provide the detail of UC standard. I don't really want to know the detail. I just want to have an idea what sort of thing is meant by it. Does it mean, say, you're 70% sure, or does it mean... Well, what is a standard of verification of identity? I can't conceptually understand what sort of thing it is.
Yes.
Maybe you don't know either, in which case...
Well, I know in the sense that I understand the process involved, but the court asked me a more specific question, which is, well, obviously you know what their name is and what they're saying their name is, and you're obviously satisfied that they produced an identity document. Is that sufficient? I think that's the court's question.
Well, it wasn't, but it would have been a good question that I could have asked.
Yes, so the process will involve you presenting, i.e. making your application and saying who you are and what your characteristics are, and having some corroboration in the form of an identity document for that purpose.
When you say that,
Yes.
you told us earlier that all claims for UC have to be made in an online form.
Yes.
How do you present evidence of identity in an online form?
I'll show you. It's in the evidence.
Okay. Thank you.
Basically, you upload it. Certainly in the new scheme, and previously you posted it.
Right.
But now we're moving, with the benefit of more sophisticated technology, to doing it all digitally. Because the current position is that technology exists for one to use a smartphone, for example. So that is the direction of travel, and the evidence that I'll show you in a moment is that this is largely now done digitally. But
is there a problem of access? Are there some claimants who don't have access?
Absolutely, yeah. So they'll need to post it, and that's in the evidence.
Right.
So let me go through all of it, and then perhaps work out what...
Keep going then.
Yeah. So UC standards, such as they are then, that is a process of verification. But what I observe and ask the court just to note here is that that is not the same as the NIno process of verification, which is done to different standards by different officers.
It's certainly done by different officers. How do we know that there's different standards?
Well, let's go.
It says so further on, does it? It's okay.
Now 20 then is, I think, the answer, albeit perhaps not explicit to the court's initial question. Does the claimant positively have to make the application? And the answer is that it is initiated by the department. That is how it operates.
Yeah. So again, I'm not trying to beat anyone up, but just to understand, this is a departure from the statute, but you say it's one that doesn't do anyone any harm. It effectively deems them to make an application which they ought to make.
Yes, I'm not on my feet going to say that it is a departure from the statute. If that needs to be argued out, it should be done properly. But I can see why it could be a departure from the statute.
Well, as far as it lies with me, I won't be trying to say anything to make difficulties for the department.
Right.
Anyone reading the judgment will look at the thing and will want to understand what is the application referred to. And so far, it seems to be becoming increasingly clear there isn't an application as such, but the department treats an application as having been made.
There's not an application from the claimant, which is, I think, obviously what the legislation would seem to suggest. Now, the application then is made on their behalf.
Yeah.
Right, so paragraph 21 then, there's the basic conditions of UC eligibility and a special trace in completion of the benefit-inspired NIno, so the EDC I1. And then the witness says, and this is important, benefit-inspired NINOs are prioritised by the department so as to further the objective of prompt payment. The 10-day window within which NIno should be allocated is far quicker than the process would be for individuals who simply go online and apply for a NIno because they want one in order to access the labour market. The system already knows that this cohort requires prioritisation and the additional cost and resources of that, and that is the basis on which the system is structured. Then paragraph 23, so the questioning of the NIno, so identification verification to UC standards we've already seen. Then the telephony team and the enhanced checking team introduced to mitigate the loss of face-to-face appointments. The ID telephony...
Well, hang on, sorry, yes. Yeah. Process of requesting a NIno, yes, I see. Identity verification to UC standards. That has already been done.
So once that's done, then... Yes, I think that what it's supposed to read is that when there has been identification to verification to UC standards, then the following stages occur.
So I see. Okay, that means that is simply an acknowledgement that this has already been done. This is the first sentence. Not that it's done again.
No, not that it's done again. No, there's one process of identifying.
No, I agree. That makes sense, but it's not quite how it reads.
No, I see that.
Well, doesn't this mean this is what you do first? First of all, you verify it to UC standards, and this is how you do it. You telephone somebody, and in certain cases, you send it to the enhanced checking team.
Correct.
But that's not quite what my lord was suggesting.
No, I wasn't meaning to suggest anything. I just thought I was reinterpreting what I thought your answer was. So it does mean, if my lord is right, and how I read it first, that the NIno team does identify verification to UC standards.
No, not the NIno team. This is the UC. This is still at the UC stage because we haven't sent the EDC.
Oh, of course. I'm so sorry.
I think it's really.
I'm so sorry.
D, isn't it?
Yeah.
Yes, I'm confusing.
The CSIV.
Correct.
Which is said to be a different standard, although we're not given any detail about what the differences might be.
Yes.
That's absolutely right, my lord.
I'm sorry. I'm entirely at fault here. But
no, not at all.
Right.
What this suggests, 23.1, is that the way the UC agent now goes about checking identity to UC standards is it rings up the claimant.
Yeah.
But it doesn't say whether that happens in all cases or whether there's sometimes face-to-face appointments or there are other ways of doing it. But that's what it suggests.
Yeah, absolutely.
And it doesn't say whether it's gone, insofar as it used to use face-to-face appointments, it's now gone back to them after the pandemic.
No, it doesn't say that. But I'm told there might be a further point in the other. I think there's 2 points. If we just take my Lord Nugee's point first, it's a fairly, I'm not going to say rudimentary because there obviously is still a process involved, but the Universal Credit agent is dealing with the first provisional determination of the caseload of 6 million as it was during the pandemic. That is not a detailed and intensive process. And most of those are going to be people who already have a NIno. And therefore that is going to be something which is going to be established early on in the process. That's why one will have fairly prompt universal credit payments in most cases. So we're dealing though with the cohort in which all of the issues arise at the second stage because they don't have the NIno in the first place. And that's where the additional resource comes in.
Do we have evidence as to what proportion of UC claimants don't have NINOs?
No, we don't. It doesn't matter. But it's obviously a small proportion because one knows that everybody, irrespective of nationality, who is here, subject to my Lord's point, but assuming that everybody still does receive one at the age of 16, then everybody who accesses the labour market will independently receive one. So people who are coming into the United Kingdom to work will obtain one. One only has then the cohort of individuals who've immigrated into the United Kingdom, never previously been here, never previously worked here. Now, it's still a reasonably significant overall number, but as a proportion, it's self-evidently fairly small.
Well, can I just make one factual point? There's a slight difference between the two witness statements, which is directly relevant to questions your lordships have been asking. And if it's best is seen if your lordships put 23.1 of the Bui witness statement, which we've just been looking at, alongside 24.1 of the other witness statement, which is at page 85, page 85 of the core bundle. 24.1 of this witness statement states that the very last sentence, these arrangements ended when face-to-face appointments will be introduced in late 2021. So it looks, it's up to Mr. Brown to say whether this is right or not.
No, that is right. I have a note to that effect. So the one that's at 15 is the slightly later witness statement. So it updates the position slightly.
Yes, I see. Well, it was perhaps my fault to insist on looking at the other one, but it was because it's what Mr. Drabble had taken that had marked up.
No, that is. I think we consent to try and understand what the factual position is now.
Might be useful, just, sorry to load work on your juniors, but that's what they're for. Just, could someone do the exercise of checking any other factual differences between the two, so that in judgment writing, we'll be working on the most up-to-date basis.
Yeah, well, certainly the one at 15 is the more up-to-date evidence. It's dated 26th of April 2022 as opposed to 22nd of October 2021.
Yes, so it's whatever it is, 6 months later. More than 6 months later, yes, 8 months later. 6 months later.
With hindsight, perhaps we should have used it throughout, but it's only these small points of detail I think that really...
No, but one wants to get it right.
Absolutely.
So if you just, insofar as you can do on your feet, now we are working on the other one.
Yeah.
Just draw our attention as you go along to any change, any
we will.
differences.
Yes.
Yes, thank you.
So what really matters then is section D. And the witness says the allocation of NInos is a separate specialised function within the department. After the UT team completed the process for requesting a NIno and submitted the EDCI 1 form, NIno decision makers make an independent assessment of each application, verifying identity to medium confidence level, in line with the department's common standard of identity verification, and that the applicant has the right to reside and access to public funds within the UK. And the process is set out in paragraph 26. But the court will appreciate that this is a summary because this is not only a specialised internal function, but it is a confidential one. It's one that's carried out by security cleared officers, and it is not challenged, and therefore it is not helpful or in the interest of anybody for there to be full detail as to what those security cleared officers actually do beyond the summary that's set out here. They carry out traces using government infrastructure, as one would expect. So that is set out 26.1. Specialist traces undertaken to establish if the applicant already has a NIno. If the NIno is traced, the NIno is noted and returned. If it's not traced, then there is another telephone interview to complete the NIno application, which collects personal information, in particular previous names and addresses. This is further information, some of which has not been gathered before. Why? Because that's what's necessary. Then NIno decision maker conducts a further trace, taking into account any additional information. And 4 checks are then conducted against Home Office sources. That's a different government department, which the Universal Credit Officer does not have access. It doesn't say that there, but I'll tell you. The NIno decision maker needs to be satisfied that all the information presented with the NIno application matches the information on the Home Office system, such that the identity and immigration status are valid. And then verification to the CSIV standard, and then it is allocated. 26.6, once allocated, it will remain on the system for the lifetime of the applicant and beyond. NIno for deceased applicants remains on our system as a fraud prevention measure for 50 years. And then it is recorded and returned by email to the UC requester. Then normal turnaround time is 10 working days. However, if it is highlighted as urgent, they're prioritised dealt with immediately. And then obviously that means that others will be deprioritised. Then 28, in complex cases, for example, if there's a discrepancy, it may be necessary to engage with Home Office colleagues. However, this was rare and was not a factor in the claimant's case. Now, advance payments. The way that this is approached, so the need to ensure prompt payment is addressed by the executive decision to invest in the prompt allocation of NINOs, because we say that this is a pure question of values. There is no values to make advance payments for reasons that we'll come on to in due course. Then there's a claimant's case.
So hang on.
Yeah.
But obviously, quite rightly, Ms Johnson is not arguing a point of law, so that's a point you're going to make.
Yeah.
She says that the system is designed such that they can't receive any payment from UC, and then she goes on the next sentence to say, without a fully verified NIno, and this includes payment of any advances. But it's not suggested that if you had the vires, which you say you don't, there's no reason why the system couldn't be designed to allow advance payments.
You can design any system to do anything.
Right. I just wanted to be clear about this, is we're not... you do see cases, seen them with you before, where it said that it would be incredibly difficult for all sorts of reasons to design a system which allowed you to make advance payments. That's not the case being advanced. She's simply saying it isn't done here.
Well, the witness does say that it would be disruptive.
Well, any change would be disruptive, obviously. If you've proceeded on what, let's assume we decide, is a wrong basis in law, it'll be disruptive to adjust your systems so that they allow you to make payments you should have been making all along. But that's not a good argument by itself.
No.
No.
There's 2 points really. The first is, well, it's disruptive, but also you're taking away the one tool which mitigates against fraud. So how is that done? Do we just tolerate the fraud that arises from what the court has determined to be the interpretation of the legislation? Or do we have to do something else, knowing that we can no longer use our key anti-fraud mechanism, because the court said that's the wrong interpretation? So it's the twofold approach. So the computer system, yes, the department goes back and redesigns it, and no doubt that can be done. The second part, which is perhaps the one that's more problematic. So what do we do then in fraud cases? So the claimant's case then, mistakes are made, mistakes are acknowledged. It's obviously right that cases where there have been mistakes are used as the vehicle for the challenge, and there's no complaint about that at all. But there is no proper suggestion that there's some unlawful rate of error, as it were. Indeed, there's very little evidence of there being any actual error, albeit there were mistakes in this case. Now, section G is of considerable importance because ultimately, and this is a point made or raised with my Lord Logist Nugee right at the outset of the submissions. We're not talking about overall payment levels here. We're just talking about cash flow and time of payment. So what we're actually concerned about is putting in place a system that ensures that the payment can be made as quickly as possible. We say that that is what the legislation effectively requires. And that fundamentally then is about recognising where the potential areas of delay are, knowing that this is a process that by its nature is going to take some time, and then trying to eliminate the potential delays. And this is really directed towards appellants ground 3. They say, well, we think it would be better if you just use your administrative resource sooner in the process. So send it off to the NIno team as soon as they present their application, even if they're not actually eligible. The department takes a different view, same objective, make the payment as promptly as possible, but a different means for doing that. And that is to eliminate the potential causes of delay. And that's what the witness explains. We will need to go to the second witness statement in a moment. So the first witness statement was in October. It's mainly just about improving the processes to eliminate human error. And the witness makes the point that there's only so much you can realistically do in the middle of a pandemic. What it is important to ask you to look at those at tab 15, because this answers some of the court's other questions. So paragraph 31 on page 89. This is described as a new apply for a NIno service trial. So this is now, as of today, rolled out, or being still certainly far more widespread than the two-site trial.
So sorry. We're looking at them now at the more recent statement.
Yes.
So you say take page 89. Yes, I see. Yeah.
Paragraph 31. So the NIno allocation team is currently trialling a new apply for NIno service. Part of the process of continually reviewing, etc., etc. It replaces the agent-led telephone interview with an online form where claimants can upload their own documents and complete a questionnaire. So the court has asked, how do they provide their documents? Under this scheme, they are uploaded digitally for those who can do that. And then 32, the EDCI1 form will play a key role in this process, as the claimant's contact number will be taken from that. The AFN application will ask the claimant whether they've been invited by the department to make the application. The claimant will have 48 hours to complete their online application and be their responsibility to do so. So that perhaps steers the process more towards the more natural reading of Form B. Mm-hmm. And then there's various prompts to make sure people do it. And 33, my Lord's question, for claimants who do not have access to a smartphone or computer, or if there are issues updating documents, there's a dedicated helpline telephone number. The option of an agent-led telephone interview will remain in place, and claimants will retain the ability to post documents to the relevant NIno allocation centre. That, I am told, is considered to be successful. That's how it's what we're moving towards.
Yes, I mean we're now a year later.
Yes.
Yes.
But what that does tell you then is that there is certainly a bifurcation of approach, and we say, and ask the court to accept as the tribunal accepts, that you should accept the evidence for that. It's always possible to provide more detail, but the evidence is clear that this is done for good reason. The state doesn't employ this large team for no good reason. On the contrary, there's a perfectly obvious reason for it. So with that then, I propose to go to the statute.
Yes, just to note, before we leave, but we already have left, the later of the two AJ statements, the one at 15, the, as you would expect, the final section G does actually contain quite a lot of new material. It seems to, I haven't analysed it, but
Yes.
okay.
Let me just check a minute. Yes, and it's that the claimants really have to overcome as part of their ground 3, because if they're going to launch an irrationality challenge, then it's not just good enough to say, well, we consider that there's room for improvement in the following respects. Not least because that itself is not an indicator of irrationality. Room for improvement is not the same as irrationality, and we've had that debate in previous cases. And we say that in circumstances where the court has evidence which is detailed, setting out what is being done, and that evidence is provided by a specialist officer who has regard to the overall framework and how different aspects interact with each other, and there has to be a high degree of reticence for the court concludes that it's rational.
I mean, not to talk in code, I assume you're talking about the Pantelaristo case. We said exactly, well, we said something rather like that. That acknowledging there's room for improvement does not mean that it's irrational.
Indeed.
Particularly if you take steps to put it right once you have.
Absolutely so. Yes. Yes, you did say that, and I am adopting that from Pantelaristo.
Yeah.
And for that, we lost in the case before my lord in Johnson, where there was a very stark issue which was capable of remediation. And the alternative evidence that the Secretary of State provided to the court didn't withstand proper scrutiny. But none of that has been said here. They're not suggesting that everything in the final paragraphs of the Johnson witness statements is simply wrong. They're just saying, well, we consider that there's room for improvement here.
Okay.
So really then, this case is about fundamentally ground 2, because that then, we say, does properly direct the approach to ground 1, and ground 3 falls away. But just dealing specifically with ground 2, then, so this is a pure point of interpretation. So the court has the provision.
No, but
Authorities.
it will now.
Page 11.
Yep.
So the court knows then that there are 2 stages. The first is what I have described as eligibility, which are the criteria in the Welfare Reform Act and the secondary legislation. So the general eligibility for benefit, here universal credit.
Is that terminology? You draw a distinction between eligibility and entitlement. Is that terminology in the statute?
No.
I didn't think it was.
No.
I didn't think I could see it.
It isn't. And if one actually looks at the advance payments regulations, they refer to entitlement in a general sense, which...
So I think does the Welfare Reform Act.
Yes.
It says you're entitled to universal credit if.
Yes. So how then do we describe it?
Yes. It's just your convenient description, distinguishing between which boxes you need to tick in order to be eligible for benefit, and which boxes you need to tick in order to actually get the benefit.
Correct. So box A, box B, 2012 Act, 92 Act. What we are concerned with is only box B, 92 Act. So all of this is directed towards what we say is properly understood to be effectively a systems and control. It's a check on payment in circumstances where the individual has established up to that point that they are putatively entitled to benefit, eligible for benefit, whatever language you want to use. But it is, we say respectfully clear, that it is intended to operate as a system and control or check and balance in order then to prevent the state actually releasing payment unless one of the conditions has been satisfied. that serves the statutory purpose of mitigating fraud. And it does now seem to be accepted that the genesis for this is the 97 Act, and that is properly understood to be an anti-fraud measure. So that's mischief that Parliament had in mind, and it falls to be construed with regard to that. And that's a short answer in terms of all the pepper and heart material and what the Minister said, because insofar as that material is being adduced to tell us that the objective was an anti-fraud mechanism, then we already know that. It's obvious from the face of the statute and just the ordinary interpretation of it. If it's being adduced for a different purpose, namely, or notwithstanding that that was Parliament's objective, the Minister actually thought it would deliver it in a different way. Well, that's not admissible. But there wasn't particular emphasis placed on all of that material. Fundamentally, it doesn't really shed any light on what the statute means by reference to the language that Parliament has used. As to that then, you must make your claim. That's the effect of section 1.1. That's not relevant here. Then 1A, you're not entitled to the benefit unless you can satisfy 1B, and I described it as a gateway, again, just as a shorthand. Then we looked at 1BA, 1 and 2. So you either got the national insurance number in the form of a piece of evidence which proves it, so the old plastic card or the correspondence from the government agency. Or
I
you
didn't know there was a plastic card. Was there at one point when you were issued with a national insurance number, you got a card?
You did, yes.
I didn't know that. That's in the evidence somewhere, is it?
No.
No, it doesn't matter. I'm sure it's true, but I just wonder whether I'd missed it.
I have one. Mr. Joel doesn't. It all depends. Other people will have a booklet, I think, going back to prior to the plastic cards. I certainly.
I never had one, but yeah, they obviously were introduced between me and Mr. Rabble on the one hand and you on the other.
Yes.
Yeah.
I have no recollection at all of how I got my national insurance number, but I do know what it is.
Yes. So, well, quite. There we are. So everybody, well, most people will have a document. And if they don't, then it can be ascertained. 1B, critical language then. So the person makes an application for a national insurance number. Now, leaving aside my Lord Underhill's point that that's not material hereafter, to be allocated, which is accompanied by information or evidence enabling such a number to be so allocated. And it's a short point, but does Parliament mean then that, in fact, it is accompanied by information or evidence enabling such a number to be so allocated, or does it mean, as Mr. Dowell is forced to accept, the prima facie evidence? And we say that in circumstances where one knows that it's an anti-fraud measure, how can it possibly be right that a fraudulent document bounds your entitlement to payment? Because that is the logic of the appellant's argument, is that Parliament intended you to be eligible to receive payment with a fraudulent document. We say, well, it's obviously the precise opposite of the intention. They did not intend for you to be eligible with a fraudulent document. On the contrary, they've expressly provided that you have to provide information which enables such a number to be allocated. And if it's fraudulent, it doesn't do that. It doesn't enable a number to be so allocated.
Well, enable is an odd word. This is my Lord's point. I mean, you are able to allocate a national insurance number to a fraudster.
Yes, you are. I accept that. That is we could have an executive policy which says that we don't care about fraud.
Well, it wouldn't be as bad as that either. It would if the system is working. I mean, you have a fraud problem anyway, where a forged document is put in and is not spotted in this verification process.
Yeah.
Well, that you'll have anyway.
Yeah.
We're really talking about the case where somebody submits a forged document, which in a week's time or a month's time would be established as part of the verification process to be forged. And so that the only hit that the department will take is paying effectively 1 month's, maybe not even that, depending on the timings, 1 month's payment.
And depending on how the recovery mechanisms operate too, but yeah.
Well, I mean, yes. Well, the worst case is not on the basis you can't in practice recover.
Yeah, okay.
Parliament could have taken a reasonable view that in the interests of early payment, particularly if you're right that you can't have advance payments, we'll take the risk of paying you out on application as long as you've provided a passport. And the worst that can happen is it turns out to be a forged passport during the verification process, in which case you'll never get any further than the first payment. And that's 100 quid or 500 quid, and it's not the end of the world. That's not so absurd as you're making it out.
Well, what work is the language doing, which is accompanied by information or evidence enabling such a number to be so allocated? Because on this
because it would distinguish between putting in that and putting in a laundry bill, or putting in something that didn't actually purport to say what your identity was,
well, just so I
or
understand,
your nationality, or whatever you needed.
So the laundry bill is, on any view, insufficient because the policy, which isn't written down anywhere, because one could have a policy which says that we'll allocate national insurance numbers to people with laundry bills. It's obviously possible.
Yes, you could give everybody who applied for universal credit a national insurance number on a provisional basis to enable them to be paid, and then you could do all sorts of checks. But that's not what Parliament has done.
No. So what Parliament has done, we say, is that it has established that your right to benefit will crystallise at the moment you make your application accompanied by the relevant documents. This is the back payment point. That's the work that is being done by the legislation. But the words, which is accompanied by information or evidence enabling such a number to be so allocated, we say must mean actual information or evidence that on the ordinary policy approach of only allocating national insurance numbers to people who actually do present with evidence, such as it is here, passports and identity documents, etc., which are authentic, will then be entitled to receive it. The Parliament knows that there has always been executive policy making processes that require there to be a submission of documents in order to prove the entitlement. But it doesn't anywhere say that they have to be passports, etc. So we say it must be right, and I appreciate there's always a contrary argument, but it must be referring to actual authentic documents, because otherwise those words are doing nothing at all. You might as well just remove them from the statute, because you would then be saying it is just the application for universal credit.
I'm limited to the extent to which we can explore this. I'm not at the moment convinced that the words are doing nothing if they have the meaning that I put to you. It's effectively, it could have been drafted, information or evidence purporting to enable such a number to be so allocated.
Yes.
And you would say, well, it doesn't say purporting to, it says enabling. Well, fine. But I don't think you would necessarily, it all depends on the context.
Yeah.
You've really got to specify, haven't you? Or at any rate, it makes sense to specify you've got to produce the documents we need. There's then a question, which is a separate question, about have those got to be genuine documents?
Yes.
And of course, I see the obvious common sense. Of course, they've got to be genuine documents. Why would Parliament have intended anything different?
Yeah.
But there's also an argument that says that this is a mechanism for seeing people get payment before the verification process can be established. Because you'll never know whether they're genuine or not until the verification process is over. And if you're going to wait till then, they won't get payment to which they were entitled. Or they won't get it on time.
The language is doing no work in those circumstances.
Perhaps I mean slow.
Well, what is the accompanying information or evidence? So if the hypothesis is that the fraudulent passport, it does mean that you've at least tried to provide some sort of document which would establish the business case, and therefore Parliament intended that to be met. Is that the proposition the court's putting me? So I understand.
Well, putting to given that most people won't be fraudsters, most of these documents will be genuine.
Yes.
Parliament simply took the view that you put in documents of the right kind, or purporting to be of the right kind, they will be subject to a verification process. The ones which actually are not genuine will be weeded out at the end of that process, and there will be a very small hit to the exchequer proportionately. And a great advantage, which is that the genuine people, won't have to wait till the process is complete and have the kind of problems that the claimants had in this case.
That's the heart of it. But that then really just means, does information or evidence mean authentic information or evidence, or is that satisfied?
Well, fine, but I'm really just meeting your point that the words do, you're saying the whole words but accompanied by documents and so on are redundant on the point that I'm putting to you. I don't think they're redundant. They just shift the inquiry to a different place.
Yes. It is myself being slow here. So the point here is saying that all Parliament really has in mind is that you at least go through a process of providing something which looks like it could be informational evidence. I mean, it's possible. I see that, but it's just inherently unlikely.
Right. I just was worried I was missing.
No.
I don't think, and I think you're now accepting, it isn't quite as absolute as you were putting to me. Of course, there are strong arguments on both sides. That's why
I still would
Mr.
respect
Ravel
to say
got
it's
permission.
rather difficult to see what real work they're doing, if in fact you can satisfy your application process just by putting in anything which has the word passport on it, theoretically, and say, well, there you go. I don't actually have an authentic passport, but I'm presenting to you my own reproduction. But my lord, I
think we've explored this as far as we can. I obviously see what your case is. I just don't think it's quite as high as you started by putting it.
Yes, there we are. I'm not really sure if I have much more to say then on that.
Would your case be better if instead of saying enabling it said justify? You know, that's what you really mean. What they've got to provide is not something which enables the number to be allocated, because you could know, as I say, you could allocate a number to someone who puts in a false passport, but they wouldn't justify the allocation of a number.
But justifying, given that the executive decides what criteria to apply, they theoretically, on this approach, could justifiably say, well, we're just going to have an extremely low bar.
Yes, but your point is that Parliament legislates in the knowledge there is an executive policy that not anybody can have a national. You can't have a national insurance number just because you want one. You can only have one if you make out a business case.
Yeah.
And so that process of making out a business case is what the evidence or information is designed to do.
Yeah.
And your point is, if the evidence or information doesn't in fact make out that business case because it's forged or fraudulent, Parliament can't have intended you to get a national insurance number, so it can't have intended you to satisfy this requirement.
Correct.
And I think that case would be clearer if instead of using the word enabling, which is a slightly odd word, it had said justifying the allocation of such a number. I mean, that's what I think your case really is.
I agree. I think my case is that. And I agree that justifying would be clearer than enabling. That said, the difference between the two words is
small, and you say once you take into account the policy, then it's perfectly obvious what was meant.
Yeah, it doesn't flip the interpretation over to the appellant side, but I absolutely accept all of those points.
Well, as you say, it's a short point.
Yeah.
You don't want to say any more about it unless we want to ask you any more about it.
Right.
Speak for myself, I don't.
There is a point which is whether Commissioner Rowland's decision makes anything different. We say he's talking about something completely different. He's not confronting this issue at all.
Sorry, what?
Commissioner Rowland in the 2007
Yes.
decision.
I think I might find it helpful to have your submissions on, because Mr. Dreville placed some reliance on what the Commissioner said. And I don't think I've understood enough about the facts in that case to understand what was going on.
Let's look at that.
Authorities 4.3. So in terms of what was happening, it is fundamentally about the information that's being provided at the interview process. So I made the point that these are processes which are effectively superseded by the evidence that the court has seen.
Sorry, superseded by
what we now do in terms of the process of uploading documents and it all being effectively carried out through remote technology systems. So back in the relevant time here, as I understand it, the information gathering process is effectively happening at the time of the meeting.
Well, hang on. Actually, at the time of these very applications, in this case, there wasn't an uploading process, was there?
At the time of the claim forms, there
Yeah.
was not. It was no. That's something that came in.
And indeed, even on the basis of the very latest information you've given, some people, not everyone, is going to be, for the time being,
Yeah, that's.
in a position to upload material.
This is why it's a different point. This is the accompanying point, which isn't live in this appeal. This is about the binary question of whether the documents allow for the allocation of the NIno. The accompanying question which the Commission is trying to grapple with was, well, what happens if it's all coming in piecemeal? And that's a different point.
Well, funnily enough, that would be available, the facts of this case, but it's not a point that's being taken.
Correct.
Because on your explanation of the system as it works, the NIno application, which is drafted on behalf of, as you put it,
Yeah.
the claimant, will only generate its supporting information as part of the inquiries made by the NIno team.
Yeah.
They will ring someone up during the pandemic. It's not actually been made clear to me how will they then get the pass? How will they then say it is a passport? How will the passport be supplied to them during the pandemic or when they're having telephone interviews?
Yeah, I think must have been post, but I can double check that.
It must have been post. Maybe they would have said, although we don't normally some people don't like parting with their passports for reasons I understand. Maybe they were told as long as it's a certified copy or something, but who knows?
Don't think that's likely.
You're entitled to say this isn't a way that this isn't a point that was taken in the case. So
yeah, I mean, certified copies for official documents such as passports, things like that. One uses the original or proper analysis of the original.
And probably for a benefit claimant, it's more difficult to get a certified copy of a passport than it is actually just to put it in the post
or to use your phone.
Anyway, I'm sorry, I distracted you, but it was slightly relevant to the Roland situation. Yeah.
Yeah. So the Commission is concerned with basically what material needs to be provided by whom and when at what stage. He is not at any point deciding this question as to what the information or evidence actually means. And that's what's at the heart of all of this. It's all very interesting, but it's not addressing this point. That's
What exactly were the facts?
Yes, so paragraph 5. So claimant who becomes eligible during the course of the process so rather than me trying to synthesise, I'm afraid I think it is easiest just to read paragraph 5. And then one really does need to go all the way through to paragraph 12 though, and that's the difficulty, is that it's all fairly dense single spaced analysis.
Right, it is very difficult to get to the bottom of.
It is. The reason why I'm trying to summarise it is I think it's about the evidence that well, the accompanying art and what's provided when. So one sees that from the sidelined passages. So 29. And the complaint then is about person attending in the meeting but not having been told precisely what the Secretary of State would accept as being relevant evidence. We'll see that at the end of paragraph 29. Then there's paragraph 30 analysis about what the word accompanied means, but the word accompanied is irrelevant here. Or at least is not the issue.
Well, we can always say that we're not bound by it anyway. Yeah. Well, I think this makes good your point that it's really simply concerned with what counts as the evidence.
Yeah. I've just been given a note in specific response to my question, was it always by post? Apparently there is...
So it's always...
Not always by post, because there is a way of using Home Office systems to verify documents without actually having the physical passport, I am told. However, that is something that is done by the NIno team with access to that. I'm happy to try and have another go of shedding more light on what Commissioner Rowland is doing. I wonder if that's better done in writing if the court thinks that's particularly relevant. Now, our submissions in our schedule and argument are that it is a different point, and it plainly is a different point. The question of what the Secretary of State needs or says to an individual they need to bring along, and what information needs to be brought to the interview, and whether that means that the accompanying definition.
My lord who asked a question, so I'll let him say. It doesn't sound as though he wants any further.
Well, if you want to put in written submissions, we'll read them. But I have your submission, but it's not concerned with the authenticity of information, but the timing of information.
It is not an easy decision.
It's not one you can glance at and pick up.
No, and we had argument on it below, and I've obviously read it a number of times. It's difficult to see how it sheds any light on the issue that is before the court. So my submission is it is not actually helpful. In any event, we're in the Court of Appeal. It isn't binding. It's old systems, and whereas the legislation B1B is the same, that's as far as it goes, but it's really dealing with a completely different set of facts and circumstances. So I'm not then proposing to say anything about Pepper and Hart. You've got our argument in writing. It just doesn't shed light.
Well, on round two, it was been about to be abandoned by Mr. Travel, I think.
Very good. for ground one then, that's where I'm going now.
Yes.
So we say that if the court accepts then the logic of the evidence, and we say the structure, namely that there's a bifurcated process, that on the first stage you're looking at Welfare Reform Act questions, 2012 Act questions, that's one category of issues for determination. That is then distinct from 1992 Act, subsection B. Then one has to appreciate that the question of verification, if that is what is required by subsection B, is what I have described as a neutral exercise. That's been criticised, but perhaps it's better described as a binary exercise.
It's a binary?
Yes, in the sense that it can only return two values, 0 or 1, that the documents are authentic or they're not authentic.
I haven't quite, or yes, well, okay, that's what neutral means, but what would you mean it to mean?
Yeah.
But why is it not possible to take a view on the likelihood of what the answer to the binary question will be at a stage where you haven't yet obtained all the information that will enable you to do so?
Because there is nothing that the Secretary of State has which would appear to be a return of 1. The Secretary of State at this stage, having decided to approach this separately, so second level decision maker, before they have verified, there is nothing other than inherent probability, which will tell you whether you're going to have...
Nothing other than inherent probability.
Yeah, that is going to tell you whether... Does that mean it's either everything or nothing?
Well, likely is a word about inherent probability.
I accept that, but one has to understand how Parliament uses it in this context and whether it's capable of having any purchase on this particular issue. So I accept that likely is a word which takes its meaning from context in particular. As all those authorities under different legislation make it clear that one can have a 50+1 or less. So you see that frequently. But here, how can that be done in circumstances where there is nothing that allows you to consider the matter one way or another? Other than the fact that...
the crudest answer would be, I have been given a passport. Looks okay, but we all know that things can be forged. But I also know, as part of my departmental knowledge, that most passports aren't forged.
Yep.
So it's likely that this person is entitled. And I'll make an advance payment. And if it turns out I'm wrong, just like when it turns out I'm wrong for any other reason, I don't know what the mechanisms are for getting back the advance payment when it shouldn't have been made, but those mechanisms are available to me.
Yes.
Well, why isn't that a legitimate exercise for the decision maker?
Because they're not actually then asking themselves whether it's likely or not, because they don't have any information to base that on.
Well, they have the example I put to you, they have their knowledge of what happens in most passport checking cases.
Yes, in which case then there is no process at all, because what you are saying is that they have satisfied all of the eligibility requirements, and therefore, because I inherently know that 90% of passports are authentic, I have to assume that the one before me is authentic.
No, not assume that it is,
Or-
but assume it's likely to be.
Well, it is, yes, absolutely. I absolutely understand it, but the effect of that is that there
Well,
is
but
no...
it's you who's making this. I appreciate there is this bifurcation, but the draftsman, I think, not actually Parliament. It's a reg, isn't it? But Reg 5.
Yeah.
Is simply asking the question: is it likely they're entitled? Which embraces both of your stages.
Well,
And the answer might be, well, certainly it's likely that they're entitled on the WRA side, because unless we've made a mistake, we've already been through that, and we
Yeah.
think they are eligible in your language. language. The only remaining question is the passport one, and we approach that in the way I just put to you. Outcome, I think it's likely that they're entitled and they're in financial need. So
in every case. So that does mean then.
well, not yes, okay.
Yeah. So that does mean that the check ceases to operate when it comes to these regulations, because in every case, the court is saying, well, you have to assume, or it is correct to assume, that because you can't know for any one case that it is in fact inauthentic, then you just have to apply the inherent likelihood, which the court says it's inherently likely, across the country perhaps, that any individual application is authentic, and I accept that. It is inherently likely. Now, what does the decision maker do then? Do they say, well, in this particular office, we're actually seeing returns which are approaching 50%, therefore we're going to refuse all of those because we know that there's a geographical phenomenon of there being a high volume of inauthentic.
Well, that would be rational, wouldn't it, if they did it? If you were in an area of very high fraud because of the characteristics of some community, or some, in this case, it would be a particular subsect, because we're dealing with only people who haven't got NINOs, who are mostly recently arrived migrants. That might conceivably, wouldn't be implausible that there would be some reason to believe that, all Mauritanian passports are forged. But this isn't a Mauritanian passport. This is a respectable country passport.
Yeah.
I'm not putting to you an absolute rule, but I'm suggesting that in the generality of cases, it would be possible to form a view from the experience in the office. And you're quite right that probably that would mostly mean that you reach a conclusion that it was likely that the person was entitled. There might be particular reasons why not. And you've just given one that what might, I suppose, conceivably be that something about the passport or whatever, we're saying passport as a shorthand, but whatever document it was that looked really very odd indeed. And a one-off decision might be made. I don't think this is likely.
Yes, absolutely. So what we are trying to do then...
Yeah, but you are making an absolute rule the other way.
I am making an absolute rule the other way, that there can never be a case. I accept that the logic of my argument is precisely that, is that the decision maker, so just leaving aside then what's happening in the UC office, assuming then that we don't rely on what they have done because they're not trained and they're not security cleared, so they don't have that know-how to reach any determination as to the likelihood question. So we have gone to the NIno...
Remind me which decision. Is it in fact the same UC decision maker who will have carried out stage one?
Yes.
Yeah.
So the same. So the UC decision maker will carry
out the one making the advance payment decision. Is that?
Yes. So yes. Assume it's being carried out by the non-security cleared team.
Yeah.
Because they're only interested in getting money out at the first stage, eligibility.
Yes, right.
Make the payment. So the second stage decision maker is the person who matters here. And the court then posits the proposition, well, why can those 400 people not just decide, and we say this is effectively what they do, just decide on the application. We say, well, they've got to carry out a process then of evaluation. So
I think what I'm saying, just putting it, is I don't quite see what the second stage person has got to do with it on mine. The first stage person, the person who has to decide whether to make a advance payment, says that the one problem this person has is they haven't got a NIno.
Yeah.
That's something that's outside my pay grade to decide, because the person the security cleared person will have to carry out certain inquiries of which I'm not competent to carry out.
Yeah.
But I've got to take a view. Why can't they take a view? Well, we're coming back to the point I put to you.
As a matter of the language, we say it cannot appear to that person that the conditions for entitlement are satisfied because they don't have any material which allows that appearance criterion.
On one element of it?
Yes, but that's a necessary element.
The statutory requirement is not that it appears that the conditions are satisfied. The statutory requirement is it appears likely that they will be satisfied.
Yes. No.
Now, that's a different... If one goes back to the previous language all that you needed was the Secretary of State concluding that somebody is or may be entitled to benefit.
Yeah.
There wasn't even any likelihood requirement. So in those circumstances, you could have made an advance payment.
No,
You say not.
I say not, because with the Supreme Court authority on likely, which would give it the same meaning as may, in disability discrimination context, it's being determined that it just means could well happen effectively.
On the cards.
Yeah, exactly. I think that's the Boyle case, as I recall it. So likely, in context, can mean a pretty low standard. I accept that. But you've got to have something in order to base that upon. And the only point really between us is whether it's good enough to have what I'm describing as the inherent probability, or my Lord Justice Underhill puts it, this general percentage type approach that most applications are probably authentic, or are authentic in fact. Is that enough to go on in an individual case?
Well, picking up a point made earlier, I don't see why this is a matter of a stage 2 NIno officers. In the case where somebody has a NIno, an application for advance payment is presumably dealt with by the UC agent because there isn't a NIno officer involved.
Yeah.
So in such a case, the application for advance payment comes in, and we're told it's usually decided on the same day. And presumably what the UC agent does is even though they haven't gone through all the checks, they look at it and say, well, it looks fine.
Exactly. Everything within their pay grade looks fine.
Looks fine. Now, why can't you in a non-NIno case have the UC agent saying, everything within my pay grade looks fine? Of course I know, this is a non-NIno case, of course I know that I'm not qualified to decide if this person's information they've put in actually justifies the grant of a NIno, the allocation of a NIno. That's not a matter for me. But I can form a view as to whether that's something that's on the cards, because general experience shows me that it is.
But all
So sorry, my question was, why did you say earlier that it was for the NIno officer to make that decision? Why is it not for the UC agent to make that decision just as they do in a NIno case?
Well, I think there's 2 points, because there's 2 different ways of looking at it. If we are looking at what the universal credit decision maker person is doing, the UC decision maker, then we accept then that they know nothing about Ruritanian passports, Ruritanian passports for the sake of argument. So all they are doing is saying, well, everything which is within my remit is satisfied.
Including verification of identity to UC standards, whatever that means.
Yeah,
yes.
Exactly. So satisfied. But I know that there is a separate check and balance in the system. I know nothing about whether that is in fact satisfied on the facts of the individual case. But because of the law of probability, I've just got to assume that it is. And that's the logic of that.
I think that is the logic of it.
Indeed. So what we're really doing
is that very different from the logic in a NIno case of the UC agent saying, I can see there's prima facie evidence that this person is resident in Great Britain. We haven't yet gone through all the checks we do go through to check that, but the likelihood is that they are resident in Great Britain. Therefore, I can make an advance payment today.
Yeah. So
what's different between that and saying, I can see I'm satisfied to UC standards that this person is who they say they are. I know there are other checks which will be done by specialist security cleared people that I don't know anything about. But on the face of it, it looks as if they're entitled to it. So what's wrong with that?
Nothing is the short answer, but it's not, we say, can't be the way that this legislation is intended to work, because the consequence of it
is that everybody would pretty well qualify unless you can see on the face of it there's something dodgy about it.
Correct, and therefore you would not have your anti-fraud mechanism in place. It would
Well, yes, but remember this is about advance payments, which is a different part of the system. Now, of course, you don't want fraud with advance payments either.
Yeah.
But the actual anti-fraud provisions are separate. They're 1A to 1C in the Act. Mm-hmm. This is the thing about advance payment is you're always going to have a higher risk of fraud or error. It doesn't have to be fraud, because you're making the payment at a stage when the inquiries which the full system requires you to do haven't yet been done.
Yes.
And that's inherent in the nature. I know it's of advance payments. I don't quite see why that's different in a no NIno case than from in a NIno case.
Well, because the nature of the exercise that is being conducted at the first stage, the 2012 Act verification exercise is a completely different exercise, because the decision maker is simply just looking at the information presented. They're not carrying out any specialised security cleared functions at all. They're just taking that information at face value, applying the statutory language of the 2012 Act and the prescriptive regulation as to entitlement to all of that, and then saying, well, system produces universal credit payment of X. There's no anti-fraud process there, other than the fact that they obviously do just require you to have some evidence of who you say you are.
Is your submission this, that in order to be entitled to benefit, you have to satisfy two sets of requirements? There's the, what you call eligibility, the Welfare Reform Act requirements,
Yeah.
which we'll call box A. You have to tick box A, and there's the anti-fraud requirements, which is the NIno one,
Yeah.
which we'll call box B. And I think your submission is this: the UC agent, if asked for an advance payment, can form a view as to whether box A is or is likely to be satisfied, because that's within his competence. But when it comes to box B, he has to simply throw up his hands in horror and say, this is entirely something I know nothing about. It's just a black box, and so I cannot form any view as to whether box B is likely to be satisfied. That's not for me. I just can't do it. Is that your submission?
Well, the way that my law puts it isn't the way I put it at all, because
I'm trying to understand.
But it is a perhaps slightly tendentious way
Yes.
of approach of stating the substance of your submission.
no, because my law's putting the focus on the UC decision maker, whereas I was prepared to acknowledge that it could be either.
Yes. So if that's right, and then the UC agent just can't decide
Yes.
whether it's like. I mean, I think that's what you mean by saying it's neutral. You just it's either A or B, but you've got no criterion by
Correct.
which to say whether it's likely to end up as A or B.
Correct.
So then you have to push it off to the NIno officer, who is able to form
Yes.
a view of that.
Yeah.
But you say he can't form a view as to whether it's going one way or the other without doing the process. And by the time you've done the process, you've done the process.
Correct.
Is
That is my submission.
but-
and
but-
that
but-
has
but
a
hang on.
yes.
All right, sorry, yes. But once you acknowledge it can be done by the NIno officer, who does know a bit more about this, why can't the NIno officer do the same finger in the air assessment as the UC officer does about the habitual residence test?
Well, yes, but that's just putting the same point. Is that, well, why can't they just say, well, I don't know because I've not verified, but I happen to know that these passports are inherently suspicious and these ones are inherently more plausible, and therefore I'll just apply the laws of probability to the exercise rather than any judgment based on material. I mean, that is the only answer to this, is that if it's as the appellants say, is that you are only applying extraneous probability, i.e. just what would happen in any given case, as opposed to carrying out any exercise by reference to the case before you.
Okay, I
There's
think I
no
now
middle
understand
ground.
what your submission. Your submission now is that likely requires the person deciding whether to make an advance payment to form a view as to the likelihood, which has to be based on the individual case.
Yeah.
That's your submission, and that it's not possible to form a view as to that likelihood just by appeal to general experience.
Correct.
That is really what you're saying. And
Yes.
once you say that there has to be material in the individual case which enables the decision maker to come to a conclusion but it's likely, then you say you can't do that till you've done the checks.
Correct. It's only when you've done it, then you flip from 0 to 1. And that's what the process actually does, because then in fact it's verified, and therefore payment is released.
Factually, that can't be quite right, can it? Because you could get a passport where even a layperson could see this is a very dodgy document, doesn't look like the real thing at all. And although, in order to be absolutely sure about that, and it just hasn't been put in the washing machine by mistake, I would have to go through the processes required, I can form a view now that it's likely I'm going to find this is a forgery.
Yeah.
So the proposition you accepted from my lord that your process involved, as well, once I can't do it on the basis of general probabilities, then I've got to go through the whole process to the very end before I can form a view on likelihood, is more extreme than it need be, isn't it?
Well, no, I can see that it's going to be pretty straightforward to find that it's not likely in that sort of case, but the converse isn't true. Namely, to say, right, well, even to a layperson, this looks like a really genuine passport. Doesn't look like somebody's just stitched this together themselves. I don't accept that that proposition follows.
Okay, well, we've explored this probably as far as we can.
But what that means, though, is that so my submission is that you can't return values between 0 and 1 here, for want of a better way of putting it. But I can see that my lord says, well, you probably could have something pretty close to 0, fine. But you can't have something that is over the likelihood threshold, wherever one puts it, whether it's at 0.4 or 0.51 or whatever it might be, just because there isn't any actual claimant-specific material.
But I think it follows from the way the argument has gone that you're in the same camp as Mr. Grabble, although one day, at least in theory, it might be necessary to decide whether likely means 50% plus 1 or some lower test. Actually, this is a point of principle.
This is
Even if the test were rather absurdly 25% probability,
yeah,
we'd have the same problem.
we would, exactly. So it doesn't matter what. I mean, this is why I haven't bought cream holdings or any of those cases
No,
unlikely,
quite.
because I can't see that.
No. Well, you're in the same camp on that.
Yeah.
Perhaps I should just put one point to you.
Yeah.
If there are two competing approaches, which we've explored, one's got to look at the policy background.
Yeah.
If you are right on ground 2, which is the only circumstance in which ground 1 matters, is Parliament likely, if I may use that word, to have intended a situation where, in a NIno case, unlike any other class of benefit applicant or benefit claimant, there was no possibility of advance payments?
Well, what I would say to that is you don't have enough to assume that Parliament has intended that they will always be available in every situation. The language doesn't say that it's always going to be possible to make advance payments. But when this was put to be below, and certainly the Upper Tribunal lay judges, I know they're not lay judges, but the wing member judges, asking about how this interacted with the development of the extended waiting period for universal credit, because it is absolutely right, as we accepted below, that this phenomenon applied to this cohort has become more prominent because of the longer waiting period. But that itself doesn't drive the issue of legislative intention. The fact that this reveals perhaps a certain...
No, I see that, but I think that is it's a red herring, but I'm not sure the fact it's a red herring really helps. The whole point about advance payments is that there would otherwise be some delay.
Yes.
And really it doesn't matter whether the delay is long or short because of the pressures on the department.
Yes. Well, we say that the parliamentary intention of subsection 1b overrides it effectively because it is that intention which is paramount here, that anti-fraud provision. And the department's response to that is therefore to expedite and improve the process of allocating NINOs. So that's what all of the final part of the Johnston witness statement is about. So we absolutely recognise that this cuts against the policy objective of prompt payment. It does. But the answer to that is to improve the processes which allow for the NINO to be allocated as quickly as possible, which then interacts with the payment processing system.
Sorry to interrupt you. Once the NINO is allocated, even before the 5 weeks, if you got the NINO allocated after 3 weeks, you could then get an advance payment.
Yeah.
Yes. Can I be sure I've understood the evolution of a statutory material? When the Fraud Act was passed, which was 97, and this was introduced, Regulation 5 wasn't in its current form. It then just said you can make what wasn't called an advance payment. It's called a payment on account, and the only statutory precondition was that you may be entitled to benefit.
Yeah.
I mean, do you accept that in those circumstances, if you were a NIno applicant, I know it wasn't universal credit, but whatever the then benefits were, job seekers allowance and so on, if you were a NIno applicant, you could have been paid a payment on account. No. Well, but surely someone in that situation is somebody of whom it could be said, they've made a claim and they may be entitled to benefit.
It's precisely the same argument, just with slightly different statutory language. Now, my argument doesn't turn on what percentage is meant by likely or may. So it's the same approach under both schemes, namely that the effect of the 1B gateway prevents the release of payment if it's not been satisfied in every case.
Because the decision maker isn't in a position to take any view on whether it may be entitled any more than on the modern language, they're in a position to reach a view about whether it's likely to be.
Correct. Yeah.
Yes.
It is not a process that can be done because there is no evidence to do it, no material. And in those circumstances, Parliament's intention is its language. When if one assumes and accepts that that is the purpose of the 1B gateway, then it does operate to prevent release of payments unless it is in fact satisfied. That's why it becomes binary, neutral, whatever one wants to describe it as. Otherwise, it ceases to serve the function which it's intended to do.
Well, the function, this is picking up a point my lord made earlier, the function of 1B is to ensure you don't get an award of benefit if you're not entitled to a national insurance number. You have to show that you're entitled to the allocation. To use your language, you have to make out a business case.
Yeah.
And that function continues whether or not advance payments are made or not, because advance payments are only a temporary thing pending the determination of your claim.
Yeah.
And the decision on the claim is for the Secretary of State under Section 8. And once he's decided the claim, if he decides because of the 1B gateway that you don't get through that gateway, that's it. You don't get any more advance payments. And indeed, there are no doubt provisions entitling him to recover the advance payments that have been made, because it turns out you weren't entitled to benefit after all. But as my lord said, advance payments are always made in the gap between the claim being put in and the claim being decided.
Yes.
It is always inherent in that somebody may turn out not ultimately to be entitled.
Yes.
What is the fundamental difference between someone turning out not to be entitled because they can't satisfy the NIno requirements and someone turning out not to be entitled for any other reason?
Because of the different functions at the two stages of doing. So the general initial process of just matching the language of the 2012 Act and the regulations to the facts as presented.
But it's not as if people weren't concerned about fraud before 1997. Or indeed, it's not as if a 1.1b case is fundamentally different from a 1.1. Yeah, well, let's stick with that. I mean, the other criteria you have to satisfy, the eligibility criteria, can also be fraudulently appear to be satisfied. So the idea that the NIno, the no NIno situation is one where there's a unique risk of fraud and therefore should be treated differently from the eligibility criteria doesn't seem to me to be right.
Well, one has to. The whole logic of this is that one is assuming that the court's accepted that its function is anti-fraud. That is why it is there primarily. So in those circumstances, it is doing different work from the general eligibility criteria, which are simply looking to establish whether you're eligible in principle and how much you get. That's the 2012 Act criteria. They are doing something conceptually quite distinct from the second line of defence 92 Act function, which is actually intentionally looking at this issue of fraud. And they're bifurcated for a reason. So as soon as you conflate them in the way that appellants do and in the hypothesis the court has just given me, then one's ceasing to do that. And then you are then ceasing to give effect to what Parliament intended in 1997. and the relevant factual background. Because you're effectively disapplying it.
Well, you're effectively disapplying the advance payment regulations for non-NIno case. I mean, effectively what you're saying is that the practical effect of the 1BB case, if you don't have a NIno, you can't have an advance payment until you've satisfied us you're entitled to a NIno.
And my law put it as a practical effect, but I think you've been putting varies. The statute doesn't allow you to. That's what you said earlier.
Yeah,
that's the logic of your position.
Exactly. That is my position. We say we're not disapplying. We're just saying the statute doesn't allow us to. The statute could be drafted in a way which said, well, this doesn't turn on 1B at all. You can simply just do it, notwithstanding the anti-fraud check. But that's not what it says. It requires it to be likely that it's satisfied. And you can't do that on the individual case. So we say the Parliament, it hasn't provided for the payment of advance payments to that particular cohort in these circumstances. And the court is entitled to say, well, isn't that surprising that you have a particular cohort which will not receive advance payments because they're in the 1B category?
We keep saying.
But by the same token, they're also presenting in a situation where they're uniquely more likely to have fraud attached because they don't have the NIno. And the cohorts that already have the NIno have already gone through that, and therefore they're inherently less likely to be fraudulent. So one does have to be rather more careful with this cohort because they've never had the NIno in the first place.
Well, I think we probably have explored this enough.
Yes. You would appreciate that it isn't really an answer to say, well, it is undesirable that there is a cohort which one would think would be deserving and entitled to payment when one is talking effectively about hard issues of law.
No, you're obviously right. That we don't. But if you say hard-edged issues of law, but if the
it cuts both.
if the statutory language is not entirely clear, one's entitled to take a view about what Parliament's intention is likely to have been.
Absolutely so. And all I sought to do is to give you the various pieces which we say do support the Upper Tribunal's conclusion on that. It is reasoned and the reasons are sound.
Can I ask you something else about Ground 1? There's a suggestion in your skeleton that this isn't really open to the appellants. Is that a point you persist in?
I've argued it, obviously, and
well, in writing, yes.
Yes, but one has to bear in mind other cases. Is that there has to be a degree of rigour, and these points are certainly Ground 3 was not taken in any sense.
No, I'm not asking about Ground 2, but about Ground 1. I understand entirely. Ground 3 is a fact-specific challenge, but Ground 1 is a question of construction. In this case, question of how the regulations interact with the statute. And we have your submission that as to how they interact. But is it still a point of significance for you that we shouldn't be looking at this at all in this case?
It is not a point of significance now.
Thank you.
Anything else on Ground 1? No. Ground 3, you've largely anticipated, but you may still want to draw the threads together.
Do I need to trouble you on Hansard on Ground 1?
I want to say something on Hansard, so the answer may be yes on Ground 1. It's
well, in that case, you better.
Passage 477, and it's particularly relevant to the submission that even under the early forms of the advance payments reg.
Well, better safe than sorry, Mr. Brown. You better say something about Hansard on Ground 1.
477, column 412, halfway down the page.
Well, can I let written submissions speak for the points of principle about?
Yeah.
So to Ben essay then. So 477.
What's this bit? 477, 412.
Mr. Heald, the precious for experiment.
Sorry, I'm a bit behind everyone else.
The passage I want to refer, well, it's in our skeleton. but I'm just
Yes, I mean-
indicating it to Mr. Brown.
You couldn't really refer to it for the first time in reply, but anyway,
Well, I know.
we need to get to the bottom of this.
We did at least discuss it before.
Okay, well, I think
Anyway,
which page?
Page 477 of the authorities bundle,
Yeah,
column 412, looking at the top of the page.
yeah.
And there's a passage that says, it's the first 10 lines or so.
Is this in Mr. Heald's?
Mr. Heald.
Who was Mr. Heald at the time?
He was the
we
Minister.
know?
The Parliamentary Undersecretary of State. You see that on page 474.
The bit that was raised in the discussion argument was at the bottom of 477 on the right,
They're
where
both raised, actually.
okay,
They're for two different purposes.
Well, look, this is, if I may say so, slightly unsatisfactory, and I'm sorry, perhaps we put you under pressure, Mr. Drabble, but you didn't make this point first time round. You did say in passing that you weren't pressing the Hansard point on ground 2, but you retain it on ground 1, but you didn't develop it at all orally. So we're looking at this for the first time. I think the most sensible course is for you briefly to make your submission now, and then let Mr. Brown deal with it. What is your point?
The point is in answer.
Well, first of all, what do you want us to read? Because I still haven't really had a chance to read any of this.
Passage that starts alongside Mr. Heald's name.
Yeah. Well, is it the whole of the sideline
Whole
passage?
No, it's the whole. It's the whole of the first paragraph
Okay.
alongside his name.
Thank you. Let me just read it. Yes, okay, well, I see why you say
The
that
only
helps
additional
you.
point I want to make, and I will then be quiet, is that Mr. Brown has made a clear submission that even under the earlier forms of the interim payment regulations, no interim payment could be made,
Yeah.
which is flatly contradicted by Mr. Heald, for what it's worth.
Right, well, Mr. Brown, we obviously have your objections to principle, and you say that we will take them seriously. But suppose they are overcome or provisionally overcome, what do you say about whether that assists on the question of construction we're now considering on ground 1?
well, he does seem to be looking at various different things. In terms of principle, it's never been determined by a court. So this isn't even a pepper and heart situation. I think what this is being adduced for is what the minister's view on other legal provisions are, not what the relevant statutory language is designed to do in the case in point. So it's basically asking for his view as a minister as to what the law is. So that is not a recognised, admissible piece of evidence. It's not a,
You say it doesn't help us to construe the Social Security Fraud Act, which is the bill that was actually before the House.
no,
Is that what you're saying?
I think the proposition was that it's his view as to what the 1988 regulations in fact mean as a matter of law
Yes.
is relevant. But I would accept that I don't share his interpretation of that. Does that mean he's right and I'm wrong? No, it doesn't.
No, but I think your point is that the bill that he's addressing, that's going through the House in committee stage, is the fraud bill, which is what the genesis of what's now 1BB.
Yeah.
And he's not talking about what that means. He's talking about what some other,
Yeah.
what the effect of that will be on some other regulations. Or
Yes. That is what he's doing.
and you say that's not within pepper and heart.
Correct. That's not within pepper and heart.
Because pepper and heart is about saying this is what my bill means.
Yes. So in a sense, that means it's not inadmissible, but it's not relevant either, because it's not excluded by Pepper and Hart, it's just completely irrelevant. on
Well,
any
therefore
of
inadmissible.
well, yes, quite, but admissibility is discretionary as opposed to
I
constitutional.
always thought Pepper and Hart said you can't look at Hansard except. I mean,
Well,
but maybe it doesn't. But anyway, I don't think it matters. I have your submission, but it doesn't have.
yes, and if one goes down then, what he seems to be, he's looking at various things at the same time, so it's bottom of 477, he's talking about the processing of national insurance numbers. And he says it's not necessary for a number to have been allocated before a claim can be processed. Well, we agree, that's right. So the processing is triggered by the application. So it is so far removed to be of any real significance to the actual questions of interpretation that are before this court. You can't, if you're otherwise with me, to reverse your conclusion on the basis of that would not be a sound basis.
Very well. Anything else on ground one?
Nothing else on
So anything else on, well, no, I shouldn't put it that way. What do you want to say about ground three?
I'm content if the court accepts the submissions I've been making along the way, namely that the reasons why what we are doing to ensure prompt payment are themselves sufficient, and the irrationality threshold is very far from this case. I may just quickly check my notes. My Lord Justice Nugee is right. You do actually have to be part of a child benefit claim. So for those of us who aren't eligible, our children will not, it would appear, receive it automatically. So they will have to then apply, I assume. So my Lord is right. Lots of emails about the complexities of evaluating passports, but I hope that the evidence...
The complexities of what?
Evaluating passports.
No, yes.
Appreciate it. Of course, probing it.
There's a team somewhere watching on live stream, presumably, and sending you helpful emails all the time.
Yeah, and those are our submissions in a second assistant.
No, thank you very much, Mr. Brown. Yes, Mr. Bramble.
I want to reply very shortly, but on three distinct points. One is data. Secondly is the policy that we say is achieved by the wording of section 1b, the issue canvassed in argument between, in particular, Lord Justice Underhill and Mr. Brown. And the third is what information the universal credit agent would have in deciding whether or not an advance payment was relevant, material relevant to ground one. As to data, just very shortly, there are a number of points where the Secretary of State says in the skeleton and orally that things are changing and have improved. It is actually, in my respectful submission, a dearth of hard material providing information about what is actually happening. There is some material from the claimant side. And if your lordships will just glance at the witness statement, I think it's Elizabeth Strode, but certainly Miss Strode, at pages 104 to 106 of the supplementary bundle. he deals paragraphs 12 through to 18 with what material was actually sought by the NIno allocation team in Ms Bui's case before her allocation, her NIno was allocated. Your Lordship will see that rather than the allocation of a NIno, on almost no further information being sought, see paragraph 14. And your Lordship will see her summary is obviously at a fairly anecdotal level because it isn't a big survey.
Sorry, you're not speaking loud enough.
It's obviously a fairly anecdotal level because it's not a big survey, but paragraphs 15.
Well, does this really help us?
No. I mean, no, in the sense, except in a negative sense, that we ask your Lordships not to place any weight on very generalised description either of the trial scheme or of what is happening in practice. It may not help very much because we are dealing with hard issues of law, but we don't have from the department detailed information about the percentage of advance payments and matters of that sort. So there it is, that's the material from our side. Now, what is the policy? What policy objective is gained by the wording of 1B? On the construction that I advance, and which Lord Justice Underhill was putting to Mr. Brown in argument. Now, the straightforward policy objective that is achieved is that the requirement that information is provided at the time of the claim relating to potential allocation of a NIno ensures, as was canvassed in argument, that a large number of cases, almost certainly the very large majority of cases that start out without a NIno, get a NIno, or enter into the verification process for a NIno. That's a major policy gain. And as the Lordships will canvass in argument again, the downside is that in some cases the information that is being provided will not be accurate, will not be capable of being verified, or indeed will be fraudulent. But that is inherent in any, that is inherent in the situation. So words that set out to achieve that policy objective in behind 1B have to be fitted into the overall scheme of Social Security legislation, which includes Section 8 of the Social Security Act 1998. It also includes Section 9, which is the revision provision, and I think you ought to provide that for your Lordships in the next, in the immediate future. Section 9 provides for revision. Effectively, the normal provision as to timing is that if the original Section 8 decision is revised, the new decision takes effect from the date of the original decision. So you go back, if the decision is no entitlement, the decision will be revised with effect from the date of the original decision. The date of the original decision takes effect, i.e. the date of claim of the scenario we're talking about. You're simply back to no decision having been made in your favour. So we say that the scheme works, the wording of Section 1B works, by achieving the policy objective of allocating NINOs in the vast majority of cases. That is an anti-fraud objective. The wording is deliberate so as not to preclude early payment. It's enacted in a scheme where the legislature plainly knows about both Section 8, 9 and 10 is actually issue procession provisions enacted in the whole of that scheme. And it's a caricature to say that it allows fraudulent claims to be to escape the net. It puts them into the net, and there's a machinery for dealing with a situation should they turn out to be wrong. Now, and then I think the final category that I want to reply on is on the information that the Universal Credit team has during the stage 1 process that we have been discussing. My respectful submission has been a natural tendency in argument to concentrate on a single document, such as a passport. Is the passport fraudulent or not fraudulent or whatever? And but the reality of the position is that by the time that stage 1 is completed, and in fact very much earlier, the Universal Credit team will have a massive information which is indeed personal to the claimant. It will include his identity, which will have been verified the scheme as it presently works in a face-to-face interview. It will include a decision that the habitual residence test has been met. The habitual residence test doesn't only require habitual residence in the way in which a family lawyer would understand that concept, it includes the verification of the immigration status of the claimant. So the Universal Credit team knows that the claimant has a right to be resident in the UK. I don't want to get into any more detail about the nature of the HRT test. It must be satisfied that there is no condition attached to that immigration status, that there is no recourse to public funds, and that will involve consideration of some documentation emanating from the Home Office, and it requires all the other conditions of entitlement that are inherent in satisfaction of a universal credit claim. So the simple submission is that against that background, one asks the question, is the universal credit agent entitled or indeed we would say obliged to decide that it was likely that the 1B criterion was met? The answer is yes. Looking at a range of information about the specific information available respectively of the applicant, you know everything short of the actual verification of the Section 1B documentation. And on any ordinary use of language, at whatever extreme one wants to put the meaning of likely, the answer is there will be a very large number of cases in which on that claimant-specific information, it is likely the condition is satisfied. My learned friend's answer to that is that he says that you have a divide between two sets of requirements, the sets of requirements under the WRA and specific anti-fraud requirements. My submission is that what the court should do, is simply apply the wording of Section 1B and then Section 5. There is no warrant in the wording for making that distinction. It's Mr. Brown's own distinction. It is a condition of entitlement that 1B is satisfied, because it says so. Is it likely that that condition is going to be met? The round one question. The answer is yes, because the whole range of personal information about the claimant points that way at some stage during the stage 1 process. And the final point on all of this is the court will no doubt bear in mind that Regulation 5 falls to be applied in a range of situations other than Section 1B. It's a formula that applies across the board. And in my submission, Mr. Brown's plea is a plea that a special meaning be attached to the wording of Regulation 5, for which there is no basis in anything contained in 1B, or contained in a plea to look only the specific information, to ignore hypothetical information and only look at information relating to the claimant. For the reasons I've explained, there will be a mass of information relating to the claimant that is available to the universal credit argument. So we say, do not give a special meaning to Regulation 5. Let it have its normal meaning, whichever in the spectrum that is, and apply it accordingly. That is, apart from the parliamentary material, which I was going to go to, but we've seen, those are my submissions in reply.
Thank you very much. We have asked for various things as the hearing has gone on. I don't think there are any that have become wholly redundant, though points that seem important sometimes go away. I just wouldn't want if it's a huge effort to reconstruct screenshots of the whole application form. Speaking for myself, and unless I'm kicked under the table, I'd be perfectly happy to have a short agreed note of the crucial point, or to rate the point we were interested in, namely, what does the application form that you fill in online say about NINOs?
Would the court prefer the screenshots or just the note? We can certainly.
I think we'd prefer the screenshots. Anyway, can all that be provided as soon as possible? Because we're so efficient in this court, we might be getting down to writing judgments pretty soon.
Yes.
And that brings me to the other thing I just have to say, you're both very familiar with it, that we will be reserving our judgment. Draft judgments will be circulated in due course for the limited purposes identified in the Counsel General for Wales case, and only to be circulated so far as necessary beyond the immediate recipients, so far as necessary to fulfil those purposes. The object of pre-circulation is so that the parties can agree a draft order, or if they can't agree, provide short written submissions on the basis of which we can make a decision at the time of hand down. And of course, we are grateful to be alerted to any typographical or other minor factual errors. Thank you both, and the large teams behind you, both those who are actually here and those who are watching on live stream, for all the work that's obviously gone into preparing this case.